Okay, it's 06, 2:06 my local time. So it's a good moment to start. I see people are still trickling in, and we have almost all of our speakers. So apologies for the slight delay. But good morning, everybody. I hope you can hear me all well. Good morning, good afternoon, good evening to all. Welcome to all of you to this webinar organized by the Let's Talk Cyber initiative on what's next for the UN Cybercrime Convention. My name is Edoardo Ravaioli, and together with Angel, I'm the coordinator of the Let's Talk Cyber initiative, a multi-stakeholder initiative which was developed in partnership with the governments of Australia, of Canada, Global Partners Digital, Microsoft, and the European Union project EU CyberDirect. The aim of our initiative is to bring together the multi-stakeholder community to debate, to discuss, and to provide input into cybersecurity discussions at the United Nations. And thus far, we've been following discussions in the UN Open-Ended Working Group on ICT, as well as of the Ad Hoc Committee to elaborate a comprehensive international convention on countering the use of information and communication technologies for criminal purposes, which I guess is a pending name at the moment still. But of course, why we're meeting today, the topic of our discussion. Our goal is to keep the multi-stakeholder community informed about the progress of both of these processes, and we do that through a monthly newsletter, which hopefully you've all signed up to, and which I would urge you all to subscribe to and share it with your own networks and with your connections. It's a good tool to be updated on the latest developments of these two UN processes in the field of cybersecurity. We're also planning another event later this summer on this side of the equator, I guess, or this north side of the world summer. Later this summer on attributions in cyberspace. So definitely look out for the invitation on that event. Today, I have the absolute pleasure, and I do apologize, I've come down with a cold, so apologies for my voice, but I have the pleasure to moderate this session to delve deeper into what is next for the UN Cybercrime Convention and take stock of the discussion. It was initially proposed, as I'm sure you all know, by Russia to the United Nations in 2017. The Comprehensive International Convention on Countering the Use of Information and Communication Technologies for Criminal Purposes, which is simply referred to as the Cybercrime Treaty, was designed to create a global framework to combat cybercrime. Negotiations for the new Cybercrime Treaty began in 2021. However, despite 3 years of deliberations, negotiations, and processes, member states failed to reach a final agreement at the last session in January. There is an upcoming session which will focus on finalizing the Cybercrime Convention, which has been reconvened in New York between the 29th of July and the 9th of August. We'll talk a little bit more about also what happens next in terms of next steps and the timeline looking into the United Nations General Assembly in September. To advance negotiations, we're expecting a new draft from the chair, and informal conversations are currently taking place, and I think we look forward to hear sort of a bit of insights into what is happening there and how those discussions are progressing. The way we've scheduled our we've designed our discussion today is following some of the more sort of contentious points, which are still question marks in the negotiations. The treaty's scope, as some states seek a broader convention, while others want a more narrow approach, and also sort of human rights safeguards, which is something we'll focus on as well in this discussion. Today, the idea is to take stock of the negotiations, discuss the risks and the challenges on the future of cybercrime treaty, and we have brought together a really stellar panel. I'm so happy you could all join us despite power cuts, delays, and everything. So it's really great to see you all in your different time zones. So thank you also for accommodating this very comfortable 2 p.m. Brussels time. With the help of our panel, who is actually just turned on their cameras, so thank you all for doing that. We'll be able to reflect on how member states can achieve the best outcome on the Cybercrime Convention and minimize risk for all. Without further ado, I want to introduce Briony Daley Whitworth, the Director of Cyber and Tech Multilateral Engagement Sections at the Government of Australia, Katitza Rodríguez, Policy Director for Global Privacy at the Electronic Frontiers Foundation, Raman Singh Chima, the Asia Pacific Policy Director and Senior International Counsel at Access Now, Paloma Lara Castro, the coordinator for public policy at Derechos Digitales, Nick Ashton Hart, who is a senior director for digital economy at APCO and the head of the delegation of the Cybersecurity Tech Accord to the AHC proceedings. And we'll also be joined by Timea Suto, who is the global policy, digital policy lead at the International Chamber of Commerce. She's currently traveling, but she will hopefully join us later today to answer some of the questions on sort of the industry side. As I mentioned, and I'm going to shut up very soon, but we have discussed we have divided the discussion in 4 sections. We'll first focus a bit on the background and sort of general views on the risks and the challenges, as well as the kind of progress of what's going on with the AHC. We'll then touch upon the sort of contentious point of the scope. We'll dive into human rights safeguards and then finally take stock of what comes next, which should hopefully bring us to, at the very least, I'm hoping 20 minutes for potential Q&A with our panelists from the audience. In terms of just a couple of logistical points, the event is on the record and will be recorded and posted on our website, the LetsTalkCyber.org. If you are joining us, please do mute yourself and turn your camera off when not speaking. We'll have a session when you can introduce yourself and ask any questions to the panelists. And of course, feel free to pop in any questions in the chat, and we'll get to those at the end of the sessions. So thank you all for joining us. Thank you to our panelists. I want to dive right in. I don't think any of you need an introduction, but do feel free to say hello, who you are, where you work, when I turn over to you. But let's start with the first section, sort of general views, developments on the negotiations. And I want to start with you, Briony. I know you've been involved quite extensively in the negotiations since the beginning. You're one of the 13 vice chairs of the Ad Hoc Committee on Cybercrime. So maybe can you help us paint a picture of where we are at the moment? What's the current status of the negotiations, and whether maybe there have been any recent breakthroughs or developments which are worthy of notice as we head into this final session?
Thank you so much, Edoardo, and it is absolutely wonderful to be here tonight or this morning for some of you, or this afternoon. I'm really excited to hear particularly from so many diverse stakeholders. I think sometimes we accidentally lump stakeholders into one bucket, and that is not the case. I like hearing from very different voices. I always learn from everyone on this panel, so I'm happy to go away with some good ideas. But as you rightly say, Edoardo, we've been doing this for 2.5 years of substantive negotiations, and we did some, 2 years of modalities negotiations before that, so we are well and truly in the thick of it. And sadly, still do not have a draft convention as we were hoping to have in February. But we do have a mandate that is ending in September. And we'll get to that, but that does put a lot of pressure on us to really get through the outstanding issues that remain. In February, when we concluded that what was meant to be the concluding session, there was still some very, very big and quite contentious issues undecided at the end of that session. But I do also want to note that about 75% of the text has been agreed ad referendum. So we do have, I think it's like 78 or 79%. So we do have a good chunk of the text already agreed. And those are the sorts of things that are actually practical and technical on what the crimes are, most of them, not all of them, that all countries should criminalize, what procedural measures countries can use to investigate those crimes, and some of the methods of cooperation that they can use to share evidence. But we do have quite a few very big outstanding issues, which you've mentioned, some of the most contentious ones, Edoardo. And so the chair reconvened an informal session in April in Vienna to try and discuss and move forward on some of these issues. This was an informal session, so it was open to member states and didn't really have multi-stakeholder participation, which we were a bit disappointed with. But luckily we have a lot of friends in the community who were able to still provide input throughout that period, which we've always listened to. The big issues that we spoke about in April really revolved around first the scope and the safeguards issue, which we're going to get to. The criminalisation chapter, so this is the chapter that provides for the crimes that all countries should criminalise in their domestic legislation. Most of these are pretty well agreed. The outstanding issues there revolve around some of the elements of mens rea, so what sort of intention or a person should have if they are committing this sort of crime. Also, the child abuse offences, which if you've been following this process for any period of time will know that they are a big priority for Australia to make sure that we have adequate, if not very ambitious offences in this convention that criminalise online child abuse and exploitation. And we also had a few new issues raised in the last few months around the other content offences, being the non-consensual sharing of intimate images. So we are trying to work through some of those issues offline. I don't think much progress was made in the actual session itself in April on these issues, but since then a lot of the countries who are most interested have been discussing these offline, and I do think that we are getting closer to a way forward there. On the international cooperation and the procedural measures chapters, these are pretty well decided for the most part. There are a couple of exceptions around where whether some things should be mandatory or discretionary. The big thing here that is still undecided is the scope. So we know what countries can do to investigate certain crimes, and we know how they can share the data or the evidence received through those investigations. We just are still very much discussing what scope of crimes those procedural measures or those international cooperation mechanisms apply to, and that is still a very contentious issue. The other issues that were discussed a little bit less fulsomely, but were still very important in April, were around stakeholder engagement in the implementation mechanism, the Conference of Parties or Conference of State Parties. This remains something quite contentious. Gender and inclusion of gender references remains contentious. The title, as you alluded to, of the convention is something that it remains very difficult. There is a lot of adamant discussion there. We did have a few proposals put forward by some countries. The United States put forward a proposal to expand the human rights article to include a way of excluding certain crimes from the operation of the convention. China put forward a proposal on expanding the scope of the international cooperation chapter so that countries could cooperate with each other on all the offences in the convention, if so agreed by them, using these mechanisms. So that would be a broadening of the scope of the international cooperation chapter. And then there was a lot of discussion also around the idea of additional crimes being included in the convention under immediate negotiations of protocols under the convention. And so that also remains a very contentious issue because that is related to the scope question as well. I might stop there with that update, but I'm very keen to get into the details of some of these issues with the people on the line. Thanks.
Thanks, Briony. I think that sort of really helps us understand where we are, and I think appreciate also the fact that you have highlighted that 79% of the text has been agreed, so there are some positives. What we want to get into today is how we make sure that we as the multi-stakeholder community can support states and ensure that that last sort of 25 to 21% is up to scratch and able to sort of protect what we're all sort of fighting for. Speaking on to sort of turning over to our stellar multi-stakeholder partners, over the last 2 years, there's been increased sort of industry and civil society advocacy for significant changes in the treaty. I think we can also agree that we've seen we could even say unprecedented civil society and industry alignment on a lot of issues. I want to turn over maybe initially to Raman, over to you. Without just diving into the details of the convention just yet, can you tell us a little bit more about the role of civil society in these negotiations and how you've sort of been participating?
Thank you, Edoardo. I'll just do a quick check. You can hear me clearly? Perfect. Delhi's electricity grid is a bit taxed by this unprecedented summer, so I just wanted to note that if I drop out, it's because this probably is a short dip. Briony's done a great job of summarizing a little bit of the situation and where the current text is. I think it's good, before I go into where society has been currently leading, to just step back a bit to the beginning. In fact, civil society's role, I think, has been often to the very genesis and positioning of this treaty process and of this negotiation, because I think from the beginning, it has been societies and trying to advise on the context and speak externally as to, is an instrument like this required? Should we be negotiated and conducted through this particular fora and in this particular manner, and what should it contain and not contain? And in that, I think, of course, it's important to note that many organizations, and not just human rights groups or digital rights groups, have expressed reservations and concerns from the beginning, saying this may not be what we require in this manner, and it can have grave consequences for cyber negotiations in general, but also for substantive impact on criminal law, cybersecurity law, and practice across countries. In many ways, societies had that sort of public, truth to power and public education function from the beginning. As the process is kicked off, as Briony mentioned, modalities did allow for civil society to partly participate, still not in any way near ideal, in some ways an improvement on some of the other previous UN cyber processes. So at least it's been clear that besides ECOSOC accredited organizations like Access Now and others, but that there can be additional organizations that have been able to take part in the process, that have been able to have a right to come to proceedings to participate. And in many ways, that's just the tip of the iceberg. Civil society has been there in the room speaking perhaps far less frequently than we would like, in far more limited a way than I think many people in the process would prefer. But we've been partly there in the rooms, but also then, of course, being able to speak to delegates right after sessions, to be able to hear the context in which they're operating in during formal sessions and outside of rooms, outside informals or more, to understand what are the problems, what is going on, what sort of context, evidence, and other material could we bring to assist people in understanding what are best practices that states should adapt and copy, whether in this instrument or outside this instrument, but also what are the mistakes they should try and avoid. Obviously, as I mentioned there, in many ways, we're ultimately limited in what we can do. We're not supposed to formally draft and negotiate. We're not supposed to be in that, but we try to do our best to aid in that process. And ultimately, we're also the ones, I think, trying to often assist delegations, but everyone involved in this process and understanding what's going on. This negotiation is still in many ways, as you noted, controversial, but actually far less visible to many people than folks perhaps might realize, right? A lot of people do not know what's being discussed in these meeting rooms in Vienna and New York, and in the many Zoom calls and other Teams calls that many of the delegates have been putting hardworking hours in. But people outside, whether those who would be impacted by the creation of these standards or those who would be seeking to enforce it, they still don't know what's going on there, and we don't often still have enough political insight or clear political clarity on how will capitals accept the final instrument, what will be accepted, what will not be. And as we mentioned, right, it's not just about what the negotiators prefer, it's about what the negotiators will be empowered to accept or allowed to sign on later, including by the elected representatives in many countries whose constitutional frameworks require, say, ratification by parliamentary approval or other processes as well. Civil society has also, of course, tried to point out very often about the abuse of cybercrime law that does take place. Sometimes we try to coach it in clear but diplomatic language on the general abuse that might take place. Other organizations have often tried to externally, outside to press and to others, explain what is going on, what are the sort of situations that are actually in play, and what can be done further there. Modalities are one thing, but ultimately the final outcome of the process is what many of us are interested in. And I think also what's definitely been the case is, as we've come to the finishing line, a lot of the processes of the AHC are focused on delegate to delegate conversation, delegate to bureau conversation, and a lot of discretionary decisions that the chair is required to make or chooses to make. It does make transparency harder. It makes input from civil society into the process much trickier. It actually often puts a lot of pressure or biases those who have the resources to get to New York, to participate in other ways, or who can regularly follow what's going on there. And in many ways, we're hoping that there are additional opportunities or windows, not necessarily change in modalities, but just practical opportunities provided by the chair, by the bureau, and by delegates as we go into the final session as such in New York. And that's something that I think we're seeing. This process has shown that civil society is crucial and important to these discussions, but the processes still leave us out in many ways. And while there may be no perfect mechanism ever, it does give us a lot of cautionary notes in terms of if this treaty were to actually be accepted, which many of us actually have strong reservations on. And I will drop in chat again a re-up to the joint statement put out by civil society as well as by civil society and industry during the previous session, expressing reservations on the current form and direction of the text. But also puts a cautionary note on if this treaty were accepted, how would its oversight body work? How would states conduct and act further? And therefore, we're also the ones sometimes helpfully or unhelpfully reminding people, it's not just about the final session in New York. We really do all need to work together on that. But it's after that in terms of the key decisions that national capitals and UN staff and other staff have in terms of how this treaty should be accepted, whether it should be accepted, and how it would be enforced. But I just give you that sort of broad picture there, and note that again, we are privileged to have ECOSOC accreditation and be there. We are privileged to join many other partners and organizations who have also been able to get accreditation, but there are many more impacted by this process who have been unable to participate. And particularly in these final rounds, the process is actually stacked against them.
Thanks, Raman. That was very comprehensive. I think that paints a clear picture of sort of what it is that the multi-stakeholder community wants to see in these discussions. Maybe I'll turn it over to Paloma and sort of your work with Derechos Digitales. Have you been able to sort of had extensive interaction with governments across Latin America? And have they been sort of taking interest in these discussions? And what's your experience been there?
Thank you, Eduardo. It's nice to see familiar faces who we work with daily in this convention. As you mentioned, just a quick introduction. I'm Paloma Lara Castro from Derechos Digitales. We are a Latin American organization with more than 19 years of experience working in the intersection of technology and human rights, offering also a gender perspective. In that sense, our work regarding the convention, first of all, as Raman already mentioned, we have been working together at civil society. So we do work as a group in many ways, this strategizing, talking to states, dividing our main points and so on. But yes, as we are from Latin America and we do have a regional perspective, we have been working towards specifically how this treaty is going to affect the region. And in this sense, I would like to point out that in the sense of history-wise, I mean, surveillance has been a key issue in Latin America, especially because it has been the main strategy for the dictatorships to occur in past years. So this is something that historically-wise should be concerning for Latin American states. And this is not something that is in the past. This is something that is present, not only because of the dictatorship history, as I mentioned, but also because Latin America has been consolidating as a dangerous region for activists, journalists, human rights defenders, and women and LGBTQI communities, especially because this is due to the fact that governments have implemented various mechanisms of repression and obstruction against the exercise of citizen civil rights. By criminalization and surveillance, there are mechanisms that are usually used to hinder the work carried out by these actors in defense of democracy and the rule of law. So taking this into account, we have been very actively engaging with Latin American states, trying to bring out these concerns. What we have noticed is that in some cases, we have received a lot of support, and I would like to mention specifically Uruguay, for example, which has been a champion carried out gender issues within this treaty. Actually, they have proposed, for example, to include the gender category within the scope of a human rights article. But sadly, this has not received a lot of support. So as we do have some champions, as I mentioned, Uruguay, also Mexico, which has a feminist exterior policy, which is different from a lot of countries. They do position themselves as feminists, which is a huge issue. We also have Colombia, and we have several other countries. Also, Brazil has been good at really engaging with civil society. They have been very open to listening to our concerns, to working together to common points, and so on. We have received a lot of support from them, and I really do want to shout out to that because it has been really positive. But I do want to point out as well that we cannot take the power imbalances out of these questions when we analyze how each country impacts on a convention. So as we are talking about consensus, as Briony mentioned all the time, that the objective of the convention is to reach consensus. So evidently, it's not just about what one country is positioning or not. So there has been power imbalances that have affected the text. In this case, the position that I mentioned by Uruguay, for example, did not pass, sadly, because it was an excellent proposition and a much needed one. In this sense, and I will go to that later on when we discuss more further issues, but it is concerning. I would like to point out this right in this minute, that it's very concerning that despite all of the advances made on international and local legislations regarding gender equality issues, we see in this treaty how this is being pushed back in a really dangerous way. It's not only about going against international law, but putting vulnerable communities at risk, at real risk. So within this context, even though some countries have been pushing for these type of issues, there has not been a lot of consent and agreement regarding these issues. So even though there is some allies within this area, it has not been the general case. So we have been engaging. There has been some countries that do support, but it's not the general case. And it has been really concerning to watch this because, as Raman said, and I'm going to end it with this, although this process does shine light on the importance of civil society, we do really have been not included in every stage of the process. Our opinion is not necessarily included in the text. We don't know how many or how much of our positions actually are being taken accounted for. And with gender especially, it ends up being a bargain chip. Not everyone really puts this as a main concern, so it just gets lost in negotiations, evidently by other countries who have very strong positions against gender rights. So this is what I can say about the general issues.
Thank you, Paloma, and thank you so much actually for highlighting sort of some of the work that you've been doing on gender, which we obviously think is key to these negotiations. I want to turn it over to industry and Nick. I know you've told me you might be in a loud place, but maybe we can try. And then Chima, who I think has also joined us. Absolute worst case scenario, we'll sort of switch in between you two to see who has the better sound. Hi, Chima, nice to see you. So turning kind of over the question to industry, there's been quite sort of extensive opportunities to be involved in the discussion, whether it was in substantive sessions or in the informals. Do you think this is a positive development? How successful has this participation been? Maybe Nick, let's start with you, and then we can see if Chima can support anything you're saying.
Maybe I should find out where Chima is sitting and go sit with her, because we're both the same very busy duo of meetings around the internet in Geneva, the AI for Good Summit and Voices Forum. It's absolutely mental here, I tell you. So apologies if I'm not very audible. I mean, on one level, I would say the modalities for participation of stakeholders in this negotiation are very much better than most treaty negotiations are. I think we have to say that on a basic level, we have more access than you would normally get. And we don't have access to everything. We don't have access to the informal meetings. That doesn't surprise me. I mean, but we have to acknowledge that we are in the room and we are able to regularly see the delegates. There is FaceTime with the delegates. The meetings are so long. There are so many long meetings that even though everybody is busy, you end up getting FaceTime sometimes multiple times in the way you don't get in other UN processes. And it's vastly superior to what's going on, for example, with the negotiation of the Pact for the Future, which is an entirely closed thing. So on that level, it is very good. As to the impact that it's having, I think we see the limitations here of a specialized negotiation where the constituency that stands to benefit from the outcome, that being justice and law enforcement, the people and prosecutors, have the pen in most, if not all, delegations. And they are not particularly interested in the wider impacts of their decisions. I had a major democracy tell me that it was okay with no transparency because at some point in the future it might be legal in their country to keep warrants secret forever. And I said, in your country, that would be unconstitutional. So I don't really think you need to preserve room for you to do unconstitutional things because someday they might be constitutional. So that's an extreme example, but it's not the only one. And I think we would have a very different negotiation if there was a different mix of decision making than we see. I'll give you one example of the practical effect of this. So Article 33 of this convention has been adopted ad referendum. It's one of the many articles that Brian mentioned. It deals with the protection of witnesses. It was copied over verbatim from the Transboundary Organized Crime Convention. And then the words, in accordance with its domestic law, were inserted into the first paragraph of the article to make what had been an obligation for witness protection into an option. So we have a situation where 20-some years after the last crime convention was adopted by the UN, we would have a new convention in which we have made witness protection weaker than before. And so this is not a theoretical situation that we find ourselves in here. We find ourselves in a reality where states are adopting provisions that are actually going backwards from one convention to the next. And this is parties to the original convention willingly adopting a weaker standard, which is not really how you are supposed to work in international law. You're not supposed to be going backwards in the same domain of law. And so I think this is one of the fundamental problems of this process is who's in the room on the state side and how much latitude they have to take decisions which no one has any business doing. We should not be going backwards on witness protection in a crime convention.
Thanks, Nick. I think that's helpful to sort of finish the painting of the overall position of where we are. Katitza, I have absolutely seen you. I have not forgotten about you. Don't worry. I'm just making my way through my list of speakers. I'm so happy that all of you could join us. And if that's okay with you, actually, I'd love to turn over to you immediately on the scope. So when we actually get into sort of the juice of what we're here to discuss. Criminal activities are supposed to be covered by this convention. It's kind of been one of the key issues that has been impeding the ability to reach the consensus. Some states are calling for a wider scope for the convention, expanding everything to cyber-enabled offenses. Others are supporting a narrow scope on core cyber-dependent crimes. Katitza, maybe I'll go over to you, and then we can also get Briony's view on this. But could you tell us maybe a little bit about what the concerns of obviously your organization, the Electronic Frontiers Foundation, but more broadly of the multi-stakeholder community are when it comes to a potential broad scope of this convention? You're on mute, Katitza.
So, okay.
Now we hear you. Fantastic. Nice to see
Thank
you.
you for the kind invitation. It's very early here in San Francisco. EFF, just a little bit. EFF, I work for the Electronic Frontier Foundation, which is an international organization working to protect human rights in the digital age. And we have been invited or involved in the UN Cybercrime Treaty even before the process started. We have always been skeptical about its necessity due to the significant risk it posed to human rights, to activists, to journalists. So that's one of our main issues. Regarding the main issues in the treaty, EFF has always argued that the convention should be narrow and limited in scope to core cybercrimes. These are crimes where computers are the direct objects and instruments of the crimes, and could not exist at all without these systems, ICT technology systems or computer systems. Core cybercrimes include the traditional offenses such as unauthorized access to systems, illegal interception, damaging, deleting, deteriorating electronic data, etc. But the treaty should be, and we think that these limitations should be across the whole treaty, not only for the section on criminalization, to focus on those, but also on the chapter of international cooperation. And we see also that the problem of the scope should be read together with the problem of the weak human rights safeguards that we have. And one thing, so this is what we want, but regrettably, the convention is broader than just cybercrime. It's not only core cybercrimes, but also they have a couple or a few cyber enables, but it also includes some very valid and important causes, but it includes some content-related crimes where it touches on speech, it touches, the way it's reading is too broad, or at least the least version that is public on the website, that could infringe on free expression. And we see the problem of the scope link or intertwine with the problem of the lack of a strong human rights safeguards. And for that, for instance, the articles that we have in human rights safeguards are very weak. The general clause on human rights is too broad, or is too light, that it only said that it has to be consistent with international human rights law, and not really states should comply with international human rights law. And then it says that it has to be applicable human rights law, instead of, some countries have not ratified the ICCPR, so the treaty should have a state which are the instruments that should be subject to this treaty. It creates loopholes for some countries to not comply with human rights. And if you read the scope together with the safeguards, it's just open the world for the treaty to be used as an instrument for transnational repression or for abuse. I will put just one example because I cannot go through all the problems with the treaty, but the treaty allows for international cooperation. It means one country can assist another in the investigation of a crime, but it's a crime deemed serious according to the treaty. And serious is only defined by the number of years of punishment. So any country in their domestic law can criminalize an activity that it's serious, like 4 years of at least a maximum penalty of 4 years imprisonment, even if that crime or that activity is not actually a crime according to international law, is inconsistent with international law. This means that, for instance, certain countries criminalize speech, even though might be protected under international human rights law. Well, the treaty is providing an avenue for international cooperation in which one country can use the surveillance powers of the treaty, the assistance provisions, to investigate this, to collect evidence for this type of crimes, even though those crimes are in violation of international human rights law. Some countries will say, well, I don't have to help. I have the option to say, I'm not going to help. But it's not about you not going to help first. That grounds for refusal, I call it more that it's more optional. It's not a mandate. And second, is that the scope of the treaty is too broad, being able to assess which crime to reject and what not, because it's in violation of international law, it will be very difficult. But what is worse, and what I think is really worse, is that a UN instrument is providing legitimacy for authoritarian regimes or for countries with very low level of human rights to cooperate on surveillance for transnational repression or for abuses, for crimes, for offenses that are activities that are legal under international law, that are protected speech, insulting the king, for example. So this is really problematic. They try to limit this also to a certain extent, but still the definition of serious crime is there, and it's as defined by national law to whatever national law, whatever country want to define serious crimes in national law. And these have even consequence, not only on the implementation of the treaty, but countries will try to pass similar laws that may be very controversial to try to trigger the powers of the treaty. So it will also create this incentive for countries to do that. And we see that already in other treaties. We see that, for instance, many countries have adopted the Budapest Convention, even though they have not ratified. They use it as a model. So there is this type of incentive when you meet and you collaborate to try to pass maybe these draconian laws, laws that are inconsistent with international law, to cooperate. So that's one of our main problems. And I can go on the on the problems of human rights. Canada has tried to fix, not totally, but fix the problem of the scope and create a beautiful provision that says nothing in the convention shall be interpreted as permitting or facilitating repression of expression, conscience, opinions, belief, people, assembly, or association, or permitting or facilitating discriminations and persecutions based on individual characteristics. This is trying to narrow the scope, but they have been rejected, even though, as you said, it has been adopted by 60 countries. It was supported by more than 60 countries. The problem of consensus tends to have a problem. The treaty should be, the international human rights law should be the red lines of the treaty. And consensus should work within the legal framework, the international human rights law, the Constitution. And many of the provisions are actually contradicting those international instruments. And for us, if you are going to compromise on human rights, on the law, on our constitutions, then, you are creating a race to the bottom of human rights protections instead of, try to put limits to the treaty so the treaty can be used to actually protect against cybercrime and not use it against us to make us more insecure, etc. So yeah, I will stop there and others can build up on that. Thank you.
Absolutely. Katitza, thank you so much. I think that's very clear, sort of your concerns and sort of the broader stakeholders' concerns with some of the provisions. It's great that you actually mentioned the proposal by Canada. I think it was Canada and a group of 66 states, as well as Australia. So maybe, Briony, turning over back to you, talk to us a little bit about this proposal. And do you think this will be enough? Is this a good direction towards finding a consensus? And are you optimistic in general that the sort of scope issue will be able to find some sort of consensus?
Thanks, Edoardo, and thanks, Katitza, as well, for that really helpful sort of overlay of where the scope and safeguards balancing has been working or not working over the last few years. For those who don't know, I might just read out one of the versions of the Canadian proposal, if that's helpful, because it has changed a little bit over the last few months. It was originally suggested by Canada back in August last year in response to the proposal to expand the scope of international cooperation to serious crimes. And so they put forward this proposal. It has been re-proposed. This proposal was originally put forward as part of the scope article in Article 3. It has been re-proposed in April by the United States, a slightly different language, as part of Article 5, the Human Rights article. And so the wording, I think the most recent one that I have is that nothing in this convention shall be interpreted as permitting suppression of expression, conscience, opinion, religion or belief, peaceful assembly or association. And I do want to draw a bit of a distinction here between two types of sort of safeguards that we're talking about when we're talking about scope and safeguards. The human rights safeguards that I know we're going to get into in a little while, when we're looking at some of these proposals, we're really trying to think about the minimum safeguards that are required for the powers and procedures under the convention, no matter what the scope of the convention is, because of the intrusive nature of those powers and the intrusive nature of the way that those powers can be exercised. And then we also have proposals like this one from Canada and now the United States, which is really trying to bring clarity to the scope of the convention by telling us what is in the convention and what is out of the convention. So which powers apply to which crimes exactly, and which measures under international cooperation will apply to which crimes or not. As Katitza mentioned, the current scope, or the scope set out in the current draft of the convention, is Australia considers very broad. It has been expanding over the past 6 months. Sorry, I'm delighted and distracted by Paloma's kitty. Hello. The scope of the convention, at the moment we have the crimes that are elaborated in Article 6 to 16. We also have other UN crimes elaborated in other UN conventions and other serious crimes for data that may be required, electronic data for those crimes. And this serious crimes concept has been borrowed from the UNTOC, the United Nations Convention on Transnational and Organised Crime, which has a minimum threshold of a 4-year penalty. But the concept itself, where being imported into our draft convention, hasn't followed UNTOC's model of qualifying serious crime the same way in its scope of application. So under UNTOC, not only does it have to have a 4-year minimum penalty threshold, but it also has to be transnational, as the title of the convention would make clear. So you have to have at least 2 countries involved, and it also has to be organised crime. So that would involve quite a few people. And so you have these additional qualifiers in the UNTOC where this proposal comes from. Whereas in the convention as it currently stands, what we have is this unqualified concept of serious crimes. And in Australia's opinion, we see that this increases the risks that the convention could be applied to conduct that's not commonly understood as criminal activity across all countries. So it is very much the case that states set different thresholds for what they consider criminal activity or not, and also different thresholds of what we might consider to be acceptable speech or acceptable expression. And of course, it is the sovereign right of every country to set their own criminal law, but the divergence between the way that these laws can be set does create difficulties when we're talking about a very vague scope and an undefined scope of the way that some of these intrusive powers might be used. Will this proposal help us get to consensus? I think that's definitely the $64 million question. Nick spoke earlier about who is actually in the room negotiating and the fact that we have a lot of prosecutors, we have a lot of criminal justice ministry experts. I am a former representative of the Ministry of Justice. I wrote our cybercrime legislation in Australia and an accidental diplomat. So I think I maybe cross across both of those. But the practical measures, clarity, logic, things that are really tangible, I have found appeal to practitioners in particular. And I am hoping very much that this proposal really provides clear guardrails. That's what it's trying to do. It's trying to tell us what is outside of the scope of this convention incredibly clearly. So I hope this does actually appeal to those practical and practitioners engaging in the negotiations. And it might actually be the diplomats like me who bring the politics into this proposal. So it is very much a wait and see on this scope issue. And I do think that there is a lot of merit in being very clear about what is out of scope of the convention, particularly given the way that the negotiations are going with proposals to increasingly broaden the scope of crimes and the scope of cooperation. Thanks.
Thank you so much. Thanks, Briony. And obviously, we hope that consensus can be reached on the specific issue. We've talked about it a lot. I'm happy that we still have about half an hour to cover human rights risks and safeguards. We don't have the full half hour to cover it, but it leaves us some time to do that. I'm going to start with Timea. We've previously mentioned one of the key concerns expressed by civil society and industry is the possibility that this text is used to undermine human rights. We've even seen the UN Office of High Commissioner for Human Rights published a note a couple of weeks ago proposing changes to the text to guarantee minimum human rights standards in the text. I know that industry is particularly concerned about cross-border data sharing. Could you maybe tell us a little bit about that and just in general what or how industry feels about the sort of lack of human rights safeguards in the convention?
Thanks, Edoardo, and thanks for having me here. Great to see everybody. I traded quiet for being late to the to the event as I just flew into Bucharest. So hi everyone from Eastern Europe. But I'm glad that I caught at least most of the conversation. On the issue that you raised, just to be clear, industry does not have an issue with data sharing across borders. We like data sharing across borders. The problem is the conditions that are set under which, for what purpose, what data, with whom, and under what protection can be shared, right? So that is something that we are very concerned with still in the treaty, and we've been concerned with it as it was progressing, and it didn't get better across the various iterations, unfortunately. And it really links with human rights issues as the first concern for us, because we know that countries have very different legal policy systems, regulatory systems, and those are not always compatible. So how do we make sure that the rights that people have under international law are actually then protected properly by those countries that have not internalized at the maximum level the international human rights law in their national law. So what do we do as industry when data is asked from us, when those human rights conflicts arise and we are put in the middle and say, okay, so are we applying our own measures here to say yes or no, or whose measures are we supposed to apply? And then are we allowed to even talk about it? Would anybody ever know that this happens? And there are good proposals in the convention. The Canadian proposal is a very helpful one that says, okay, here is some sort of minimum benchmark that you're not supposed to do. But we remain concerned not just about the issue that this has major human rights impacts, but also that a lot of the jurisdictions who have very good human rights safeguards believe that their own human rights safeguards that they have in their own constitutions, in their own legislations, are enough because that protects their own, which is great, but it does not give you the universal coverage here that we would want. So I'm putting this in very simple terms. We've put it in policies very many times, and it's there. We did it together with other stakeholder partners as well from civil society. We've talked about this directly with governments and with the chair and also on the floor. So it's to go back to the first question that you've had in terms of participation. I think it's very helpful that we have been able to do that, and that also government partners have heard us saying that, and they're championing this idea as well, so that the stakeholder input happens both formally and informally, and I want to be clear that we're very grateful to those government partners that are bringing our voices into those rooms that we are not part of. So that's one element. The other element that is not just from a human rights perspective, but from an actual industry perspective, problematic. What makes industry invest and be present in a country, right? So there's a number of financial considerations, a number of economic considerations, but also you need to protect your own workforce. You need to protect your own people that you employ. You're responsible for them. If there are certain situations in certain markets that are threatening to your own workforce, and here I'm talking about any employee of any company being able to be compelled to share information on how a company system works, or how that data is obtained, or who has it, or where it is. If that element is not protected, that you are given the tools to protect your own workers, your own employees, then it's a huge consideration of you not actually being in that jurisdiction. You're not providing your services. You're not opening up a shop there. You're definitely not going to open your data center there, which everybody wants, right? So how are we making sure that we link these conversations at a very practical, real level with conversations we have on development, on economic growth? So it's human rights. It's also very real, basic economics that we have issues with. And then there's also the national security element that others have already mentioned a lot, and I don't need to belabor the same point. But that again applies to problems for the national security officers, the governments themselves, on what happens to their data, their employees' data, as they move across jurisdictions, and we allow opportunities for that data, their data, to be accessed or tracked and I want to emphasize this, in permanent secrecy, without any transparency, without any visibility of what has happened, because then there's still in the treaty there is no limit for how long this cooperation and data sharing can actually be held secret. So those are the three big elements, right? Human rights, economics, national security, that I think are very concerning around the ways that at the moment the data access elements are treated in the convention. And I think there's still a lot of work that we need to do on that to put it into a situation where industry can say, okay, we can live with it, right? I'm not as optimistic as to say that we will ever get to a point where industry say we like it, but can we get to a point where we say we can live with that and we can support that? We can actually go to our national governments and say, okay, if you ratify this, you won't receive pushback from your own industry. So I'll leave it here, and if there's anything else that you'd like me to ask me and we have time for, of course, here.
Absolutely. Thanks, Chima. Thank you. That's really helpful to understand sort of where industry is standing here. I want to turn over, still sort of staying on the human rights risks and safeguards. I want to turn over to Katitza, to Paloma, and to Raman. Now, I think just in the interest of time and in true AHC fashion, I'm going to give you 2 to 3 minutes each to focus on sort of what it is that you would like, sort of what the message you would like to put out when it comes to these human rights risks. We've talked about collaboration between multi-stakeholders, between the stakeholder community. Your three organizations signed a letter with more than 100 other NGOs, really raising awareness on human rights risks, on the future of the convention. I'm going to start with Raman. What do you think are, for sort of your organization, you personally, what do you think are some of the main changes that need to be included in the sort of final draft in order to ensure the draft doesn't undermine human rights?
Perfect. I just want to do a quick check that you can still see me. Teams is playing with odd issues, so I can't see you all, but I'm just making sure that you can see me.
We hear you and we see you, so no issue at all. Go for it, Raman.
That's fine. I'm just gonna like focus on my issues and just like just to step back a bit. For Access Now, we are a human rights organization functioning in the digital age, but we actually provide, and the core of our work is a digital security helpline that helps activists, human rights defenders globally. So we essentially provide cybersecurity services to civil society for free, and we also track the development and implication of these laws on people. For us, in terms of what's there in the current draft, I think it's very important to note that we looked at some of the compromise language proposals around human rights safeguards, including the US's language, the Canadian proposal, and more. We are still concerned, however, that in some of the language being proposed, including specifically the safeguards provision in what is to be Article 24, that it's still not matching the human rights language and standards that are applied in international human rights law and domestically. Particularly, if you look at the language there, the only mention that's made is that of the principle of proportionality. Whereas for many of the folks who work here on international human rights law, it's an application at the national level or on even the standards that apply when data access requests are sent to providers. The legal test is actually at the very least legality, necessity, and proportionality, or if you were to look at more widely, it would be legality, non-discrimination, necessity, and proportionality. So we're deeply concerned that that test is not being fully worked in there. That's actually a watering down of international human rights law when it comes to how the right to privacy and other protected human rights apply to access to data and other procedural measures. And that's a simple, clear fix that we believe needs to be made. So if Article 24 were to be worked on, it needs to be very clear that the language there in, say, Clause 1, as well as elsewhere through the treaty, should be on incorporation of the principle of necessity, legality, and proportionality at the minimum. We believe that more language could be put in there. We also think it's crucial, again, that it be clear that human rights, this is a human rights implicating instrument. It is a provision to which standards apply. And I will let my colleagues come into that a bit more. I know they've spoken to it previously.
Maybe Paloma, would you like to jump in?
Yes, thank you. Well, following up all Raman's points, I would just like to say that neither technologies nor the criminal law are neutral, but they are inserted within societies that pre-account for existing inequalities. And as we all know, I think that not only criminal law, but also technology and the relations between the two of them do have the potential to generate more exercise of human rights, but also they do have the potential to deepen social inequality. So this is why we really do need to be very careful of how to approach an international treaty, because again, as Katitza has mentioned already, and I would just like to point out this part, this is not a new theme. I mean, it is a new convention, but this is not a new theme. This has already been covered by other conventions as well as local legislations. So what this allows us to see is that laws that are created, that are overly broad, that are vague, are being used in an abusive way for states, especially those who don't have much democratic safeguards, but still it's not the only reason. When we do draft laws that are overly broad, there is a possibility of abuse, of criminalization, and of surveillance. And this is not something that we are stating as civil society as only, but international mechanisms have already recognized there is a growing trend around the world that these legislations have been used to stifle dissent. This has been proven by us, specifically by an investigation we did, and I'm going to put it in the chat, but we did analyze how global legislations that are drafted this way and without having in account what Raman mentioned about proportionality, necessity, and legality, as well as with a lack of gender perspective, have been used to stifle dissent, and this has not only had individual consequences, but rather collectively consequences, especially regarding gender, because historically excluded communities such as women and LGBTQI communities that have been excluded from public debate are finding the digital sphere as a way to pronounce themselves, and this has already created positive contributions to public policy. But if we do stay with this drafting of this law, this will generate and is generating consequences through these communities. So if we do not take into this into account, we will generate consequences for these communities. So in the draft, as it has been included, the gender mainstreaming has been included within the preamble, but we do really want to emphasize on the need for an effective gender mainstreaming. This is not only to include it in the preamble, but also to mainstream it throughout each article. This means in data protection, in international cooperation, and so on. I mean, there on capacity building that was actually included before and excluded in the last version. I mean, I could go on forever, but I know we have little time. So it is important that I do finish with this important message that we are not talking about potential risks. We are talking about concrete harms. So if we do advance towards this kind of convention, we are legitimatizing existing legislation that is already problematic and that is endangering communities, while we're also opening up the door for the creation of new legislations which are not compliant with human rights international law. We have come a long way to ensure protection from these communities, and this treaty, as it is endangering communities. So we really do need to be very careful. And just a final message for people who do want to get more involved, we have created a website. I'm also going to share it in the group, with a campaign regarding specific messages within this. We have the letter that Raman mentioned, and also we have gathered all the contributions made by civil society and also by other international human rights mechanisms. So you can find all of this information within one website. So we hope this is going to be helpful. So I'm going to leave it at that, but I'm very happy to continue this conversation.
Thank you so much. Thank you, Paloma, and absolutely do feel free to pop the link in the chat. I'm sure people are very interested to see it. Katitza, and then I'll move over to Nick to then finalize this sort of session of the discussion. Would you like to share anything?
Yes, I just want to put a pause here, and I don't want to lose the big picture here. I support what my colleagues Raman and Paloma has said, but those are proposals to mitigate the risk of the treaty. I want to remind everyone that 78% of the text has already been agreed at referendum, and I have serious concerns with the 78% or 50. I haven't counted exactly how much it is. Things that has already agreed and that are serious and problematic is one of these Article 28.4 that require parties, the states, to put in place laws or any measures to enable their authorities to order anyone with knowledge about how computer works. It could be NGO, how computer or devices work. It could be NGO, an employee of a tech company, a security expert, to search a computer or a device. It will enable, this could involve understanding. So this will be that people who are experts or who has understanding of how the computer system works or the device works can be compelled to assist, for instance, can be the proposal as written and without the safeguard that the other treaties have, like the Budapest Convention, who could be read to compel an unwilling engineer to help break a security system. In the worst case interpretation, it might be interpreted to include disproportionate orders that can lead to forcing these people or NGOs to disclose a vulnerability, so the government can to the government that hadn't been fixed yet. So this means I am an expert, I'm traveling to a country, and I will be compelled to assist the government because I know the weakness of a system, and I have to disclose the weakness that they can be hacked. In reality, what we have asked, either remove it or ask the government should go to the company as a company to disclose the data, the data custodian, as we have said in our submissions. But that's not in the proposal. They want to bypass the person who works in the company and ask the employee to disclose that information without the company knowing. And this is also problematic because the employee will be kind of in a uncomfortable position because he has to comply with his company, and he also have to disclose things to the government, so his company get hacked. And so without the safeguards, without all the things, those are disproportionate orders, but we don't have the limitations in explanatory memorandum or anything to make sure that this language doesn't get such a broad and disproportionate interpretation. In democratic countries, we may be able to challenge that interpretation, but not be the case in others. So I'm concerned with that. And there are many other things that already have been agreed at referendum that is not acceptable. And I only have 2 minutes, so I just choose one example, but I just want to say that that's very concerning. So at this point, and I want to put that question to Briony, what could we do? Because the stakes are very high, and the text is not going in the direction that we would have hoped it goes. And I'm really just seriously concerned and with this situation. Thank you.
Thanks, Katitza. I'm hoping we can have some final thoughts from Briony and all of you as well on sort of what happens next. Maybe Nick, just sticking with this question of human rights safeguards. Would you like to add anything?
Yeah, thanks very much. And I want to also visit this larger point. I agree with everything that I've heard about specifics. One of the hallmarks of this negotiation is that NGOs in the private sector could almost literally swap our interventions in the committee and read them unedited, which is remarkable across the board. I've never seen that in international relations before, where there's such broad agreement, which should alone make states concerned. But I want to bring the Canadian and US proposal that Briony read. Even if you accept that proposal is included, and every other safeguard that has been mentioned is included, there are 8 places in this treaty where confidentiality of the powers is assumed. And there are 0 places for disclosure of any kind at any point. So in many Western states, it's true, warrants expire. You can know that your data has been used. Companies can notify you that your data has been used when a prosecution is no longer going to happen, or you're no longer a person of interest, or the case is over. But in many countries, it's not the case. And this convention will allow any states that want to keep any cooperation that they do secret forever. And in that environment, no safeguard written into the treaty actually means anything. Because if everyone can keep what they do in the dark, all they have to agree between themselves is what they want to do. And I think it should be deeply concerning to anyone that in the year 2024, the UN will bless the ability of member states to hand their personal data around the world in secret in perpetuity. That just on a basic fundamental level, how could that be justified by any democratic state, but really by any UN member state? But I don't see how that's congruent with the UN Charter.
Thanks, thanks, Nick, for that. Raman, would you like to jump in? I see your hand is up.
Briefly,
I'll try and be
perfect. Yeah, and I just wanted to build on one of those areas that Nick flagged where industry and society agree, which I often say, if industry and society agree on something, you should pay heed or be worried. And I think the main point here is you should be worried, because we're concerned that the cybercrime treaty language, when it comes to security researchers and the people who make cybersecurity possible, it directly places them at risk, right? And there's a very helpful remark also by Stefan from CIOP's Institute, more broadly about magistrates and the laws you submit. Remember, right? You deter cyber criminals by prosecuting them, but by also making systems secure. The systems are more insecure because of this treaty. You should be worried, and we've been very conscious that many states have agreed with us. But we're worried that the language we've ended up with is still far insufficient and doesn't recognize the reality of how security research happens. Very simply put, the references to authorized testing and the few other mentions there are insufficient. This current treaty text will make things worse. Not just take my word for it. I think that's what you've heard consistently from those who do cybersecurity provision in industry, civil society, or academia. We have 3 simple solutions to this, and I do encourage delegates who are interested to reach out to me and to also see the joint statement we joined with the Electronic Frontier Foundation on the overall situation on this. But from Access Now, we have 3 specific areas that we recommend. Fix the language of Articles 6.2 and 10.2 in the criminalization chapter. At the very least, remove the references to the word authorized. There is additional language that could also be considered and worked in here. Secondly, we do believe one other option to states and to the Bureau and to the chair as a whole is to add language on prosecution guidance to Article 21 around protecting good faith activities, security research, and more as well. And the third option is to alter some of the proposals that have been made to add references to security researchers in the preventive measures provision, namely, and I think that is led by the United States and supported by other states, additional language proposed in the new Article 53E. And we believe that they need to be fixes to make references not just to service providers, but to ICT systems as a whole. And again, we have guidance there that we're happy to share with delegates and anyone who's interested. But I just want to reiterate this. This cybercrime treaty must not make us more cyber insecure. The current text, unfortunately, despite best efforts, does do that. Please do absolutely pay heed to this key concern.
Thank you so much, Raman. Thank you, Nick. Thank you, Katitza and Paloma, and sort of everyone else who has contributed to this very important section of our discussion. I want to turn over to Briony just to make your life harder, to sort of begin to try to wrap up what we've been discussing in the past, but just a bit over an hour. I did say that we wanted to talk about what happens next. We also had, yes, indeed, Nick, poor Briony for being the only member states on the panel. We've heard some expressions from some member states on the fact that the human rights provisions are excessive, that this is a criminal justice instrument, it shouldn't include human rights safeguards. Do you think we'll be able to find a balance with some of these member states when it comes to trying to achieve consensus? And maybe if you can also weave us and sort of shepherd us towards also some closing remarks in terms of the procedure, what happens next, and then what I will do for the last sort of 5-6 minutes, and I fear we'll go over, is I'll just let anyone jump in for any final remarks in terms of what happens next, because I do want to make sure we finish on time. I know you're all very busy. So, Briony, over to you for sort of what happens now and what happens next.
Thank you so much. I will try and be very quick. Whether we get a convention that works is incredibly important to me personally, not just to me as a state. So I really do appreciate all of the comments and input, because it needs to work, and to work it needs to be really clear in the instructions and the guardrails around the powers. One of the things that we are always hearing, as you said, Edoardo, is that this is a criminal justice convention. Why do we need to talk about human rights here? Because we are dealing with unprecedented powers. We are dealing with very intrusive measures that have never been set at the UN level before. We do have some other places that have a lot of safeguards associated with them. But this is the first time we are doing this here. And so we really need to be very, very careful about having clear instructions, clear guardrails around these powers, these procedures, these measures, because they can be incompatible with human rights, as many of the other panelists have said, when they're used in a manner that's not reasonable, necessary, proportionate. It doesn't have legality associated with it. It's not for a legitimate objective. So it's really important to make sure we get it right, and to note that we do have different levels of intrusiveness around some of these powers. And so that's why we have different limitations and different guardrails applying to different powers, which means that we do have many more mentions of the rights, the conditions, the safeguards than might apply otherwise. Going to next steps really quickly. We are expecting the next draft revision of this convention any second now, but probably early next week. Meeting in July, and if everything goes to plan, reporting to this session of the General Assembly with a beautiful draft convention that was agreed by consensus and has all the human rights safeguards and limited scope that we want. I am, well, optimistic, also a realist. Consensus is what we're looking for. The modalities do allow for voting. That is possible at this session. So we are looking very much into how that might work while we are trying to avoid it, but not at all costs. And the role of the Bureau comes in there as well with the modalities. I think it's also really important to think about not just the text of the convention itself, but the other pieces of paper associated with it. We are also negotiating the resolution at this point in time, and the resolution right now includes a proposal to go straight into protocol negotiations that would drastically increase the scope of the convention by going into negotiations on new crimes straight away. And we have all seen the list of 20 or so crimes that many countries want to add to this convention. So that is definitely something to be thinking about. I do want to end, because I want to hear from everyone else as well, just to commend the work of the stakeholders, the civil society, industry, and others throughout this convention. It's a big commitment to be following. We need your expertise, but also your advocacy. I think Paloma made a really good point about gender. And named a couple of countries, Uruguay and Colombia, I think, who have been doing a lot of work on this, and we are incredibly impressed and supportive of that as well. And I would actually characterize it as there has been a lot of support for some of these issues around gender and including gender mainstreaming throughout the convention. Uruguay's proposal had over 50 co-sponsors. The issue is not that there's not lots of support, it's that there is also very strong opposition from a small number of states that we need to deal with on a lot of these human rights, gender and other issues. We've had sort of success in some ways through the advocacy to put gender into the convention, to think about how we protect penetration testers. We've had a lot of help from stakeholders to deal with jurisdictional issues as well around service provider locations and to be able to address some of those issues. So we have definitely seen the effects of that expertise coming through in the way that it's drafted, and I know it's not perfect yet, but there have been a lot of impacts there. The stakes are high, and the way that civil society does shed light on what is going on, I completely agree, Raman. That is such an important point and an important role to make sure that people, everyone who is affected, decision makers and the public, are aware of what is going on in the UN basements that we spend all of our lives in. Because at the end of the day, what we have in our hands here really questions the credibility and the confidence of the United Nations itself, the system, the Charter, the Universal Declaration of Human Rights, how international law can apply in cyberspace and in other new domains, and we don't want to get that wrong. Thank you.
Thank you so much. Thank you, Briony. I don't know, we're really running out of time, but I really want to make sure that everybody's had a chance to sort of put a closing statement on what happens next. So maybe Raman, I think some of yours that you've already sort of made some concluding statements on where you see it. So if that's okay, we'll hand it over to Katitza, Paloma, Nick, and Timia. Katitza, maybe starting from you.
Yeah, sorry, what was the question?
No problem. Just sort of what happens next, where you'd like to see this go. Where do we go from here?
Well,
easy question to answer in a minute, of course.
Very quickly, narrow the scope, strong human rights safeguards on Article 5, a clause on no discrimination, but not the new watered down proposal. I want the strong one from Canada that include discrimination, because many countries criminalize just being LGBTQ. Plus, some of those crimes are serious crimes. They are even death penalty. The treaty will provide a legal basis for authoritarian regimes to trigger the surveillance powers internationally for investigation of such as crimes. And this is lending democratic countries' voice to authoritarian regimes to commit those type of abuses. And that shouldn't happen in this treaty, and it shouldn't be acceptable. And that's like more than a red line. This is not only about compliance with international human rights law, which the treaty contradict a lot. It's also about not lending your reputation under the UN umbrella for giving these powers to governments to act on those issues. And I will just make this reflection. We are talking about people and life. This treaty was supposed to make cybercrime easy to investigate faster. In reality, all the discussions around data requests was to make the process faster because MLATs were slow. Well, with this broad scope and lack of human rights safeguards, it's going to make it even more slow. And it will just clog the MLAT systems, the requests, the assistance, and the expertise that each country will have to develop to comply with these demands. And so I just want to put here. And finally, we are also in agreement with security researchers. We want to make sure that they are not criminalized for their work. Most of the language is already agreed at referendum, but there are some places where we can potentially add some language to protect their work. I'm just going to stop there, and thank you so much for inviting me. I'm just really concerned. I want to share those views with everyone.
Your passion is very much appreciated, Katitza. Paloma, over to you.
Well, plus one on what Katitza has mentioned, so I know we have little time, so I'm not going to go with that. But again, this treaty can legitimize surveillance, can legitimize criminalization, and will especially affect historically marginalized communities. In that sense, just one final thought, as Briony mentioned, yes, it did not pass for strong opposition, but strong opposition really illustrates not only where the position worldwide is, but the weight that opposition has. And so what that shows us is that, as Katitza mentioned, this is not about human rights clearly. So if we do not strengthen within what has already been agreed upon the international community and upon states that are signatories of treaties that are already in place, we are just going to go back on the fights we have won, and we are going to endanger communities and endanger the way internet is working up until now and its possibilities for empowerment of communities. So we are truly concerned. We do call to action with this treaty. I mean, as Katitza mentioned, there's already a lot of agreed language on that. So I don't know what we can know about that. But I think it's important that we do keep working together, advocacy-wise, shedding light on what this convention how it will impact on this. So again, I want to turn back to what I mentioned within the website. We do have campaign there that can be used and reutilized by other organizations. So we do encourage you to use this material and also to talk to your local governments about these concerning issues. If we do not act together, this will endanger human rights in communities. So yeah, we're concerned.
Thank you, Paloma. Over to you, Nick. Final thoughts.
Well, it's easy for me because I can agree to all the things that I just heard. But I want to add two points. One is again on this transparency point, does the UN have any business blessing a secret data access treaty? Any crime or on any other basis? And I don't think that it does. I don't think in 2024 that would be legitimate. I understand the difficulty of revising ADREP paragraphs. I think 28.4 needs to be looked at very carefully. And I think I think states need to ask themselves if going backwards on witness protection is legitimate, is actually legitimate for parties to one treaty to agree to derogate from another. Because I don't think that that's a legitimate choice, aside from the obvious human rights consequences. And on the transparency question, I think states have to ask themselves if facilitating secret data access by non-free states is a legitimate. It's a known outcome. We know there are states that they can work in secret with one another to suppress dissent and minority groups, but they're going to do that. And it may be true that we can't actually make them stop behaving in this way by a UN treaty. I've heard that said to me many times by states. But the UN doesn't have to bless this behavior. And I think democratic states need to look very carefully at this and ask themselves, do they want to try and take an instrument that's flawed through their national parliaments? Do they want to have the private sector and civil society united in telling parliamentarians the truth about this? Because I don't actually think that's helpful. And they have to ask themselves, are we actually going to solve a real problem with this instrument? Or are we just going to create more problems? Because what you're hearing now, I think, is that this is not a solution to a problem. This is a problem creating exercise at this point. Because people haven't mentioned it because of time, but just as these provisions would allow the criminalization of security researchers, whistleblowers and journalists also get unauthorized data access. So there's I think a lot of reasons for states to ask themselves, a treaty at any cost is not good, and we should not endorse a bad instrument. If we can't endorse an instrument which we have high confidence will help address cybercrime, and one that will bring civil society with us, let's not do it. It would be better to say we can't do this. We tried, but we were unable to produce a result that was worth the UN.
Thank you so much, Nick. I think we've gone sort of around the virtual table, unless Timea, you want to add something as well.
Just very briefly, because I know we're out of time, and I don't want to repeat substantive points. I think we've talked a lot about what issues are here, and those issues persist, and I think we need to take that away, that we haven't solved things yet. But I don't want to crystal ball of what's gonna happen. We don't know, but what can we do between now and then? And that's what I want to focus on. And I think we need to, those of us on this panel, but also those of us those of you in the audience who've been very patient with us and very quietly listening to us. What can we do between now and then, right? So we can still talk to one another. We can still talk to our negotiators. We can still talk to our partners in civil society and business, those who haven't talked yet but should know about this and should have a voice. We can still raise awareness of what are the pitfalls that we carry on seeing. We still have some time to make those ideas heard again and again and again and again. So that is I think where we ought to focus on. I'm very much looking forward to the new draft. As Briony said, any second now. We're all waiting, and once that's there, we need to, I think, still make sure that we go through the motions, we use the voice that we've been given in this process, and make sure that we state clearly what is it that we want and what is it that we definitely do not want. That's what we can definitely control. What comes out come early August, we'll see, but it will also depend on us.
Thank you so much, Timea, for those closing words. I've posted a couple of times on our chat whether anybody has any burning questions for our panelists. I have not seen too much. I think, Raman, you addressed some of the questions that, or rather the question that Stefan posted in the chat. So if there's nothing else and nobody has any more burning questions for our panelists, I'm going to close the session out a couple of minutes late, but it was absolutely worth it, I think. I want to thank you all for joining us. Thank you all for starting your day or ending your day together. I think it was an excellent discussion. It really painted a clear picture of where we are, what we must focus at the last session of the AHC come July and August. There's still work to do. And I think there is still work that can be done as the multi-stakeholder community continuing to engage with states and sort of really sort of nailing down and harrowing on the points that we think need change in this convention. So once again, thank you all for joining us. Thank you all for giving us an hour and 40 minutes of your days. Thank you to all of our panelists and our audience. And I wish you all a pleasant day, evening, and thank you again.
Everyone.
Thank you.
Bye, everyone.